May it please your ladyship.
Yes, Mr. Adams.
I appear for the appellant. The principal respondents to this appeal are the third respondents who do not appear. The third respondents did not attend trial nor take any active part in the proceedings, merely inviting the first and second defendants to advance arguments in protection of the estate. And your ladyship will have seen they did not advance any positive case on the beneficial ownership of Cefn Coed.
And on that basis, we were content for them not to appear today.
Or allege that any beneficial ownership of Cefn Coed had been severed. And that's an important point, which I'll come on to. My learned friend, Mr. Pierce Smith, appears for the first and second respondents, who are potential beneficiaries of Lloyd's estate. The learned judge permitted both the first and second respondents to act on behalf of the estate. He mentions this in paragraph 61 of his judgment. And as I understand it, my learned friend seeks the same indulgence in this court. And my lady, you'll have to hear from him as to on what are the special circumstances that give him standing.
There's no objection to that, is there?
Well, it is irregular.
Well, has it been flagged up as an issue that we have to consider? I mean, what possible difference is it going to make to the legal point that we have to determine today?
My lady, in that case, I don't. It's a matter for this court.
Yeah, well,
Yeah.
Just while we're dealing with clearing the decks on those sort of things, I presume there's no objection to the respondent supplementary.
No, having read that carefully, there's nothing we can't deal with.
Very pragmatic, thank you. May I just again check with you, because I understand from my Lord Justice Nugee that you indicated that you were going to rely on your permission skeleton arm, which is most helpful. But could you help me with this, because I rather fear, although I've been reassured that they're in virtually identical terms, but I was working on an appellant skeleton argument, which is a good start, dated the something of August.
This year.
Thank you. The 17th of August, where at paragraphs 66 and onwards, you deal with ground 5 and refer back to a couple of paragraphs in the 20s as well. Now, I don't think that's the right skeleton argument. I think that's a different skeleton argument in very similar terms.
It's in almost identical terms. Unless my learned friend has any objection, I don't think it's going to make any difference which one we work for.
Well, could you just help us in the bundles as where the one that we're supposed to be looking at?
The PTA skeleton argument
Yes.
is in the core bundle. It's actually called appellant skeleton argument, but it's tab 3.
And that's the 27th of August.
22.
22, yeah. Oh, yes, of course. All right. So just for the purposes of, and they're virtually identical in terms.
Yes. I think the couple of passages from, I think, guessing and guessing, I set out in the second one, but I'm going to refer to those anyway.
In that case, I'll stick with the second one, which I've marked and flagged. Yeah. Thank you. Now, any other housekeeping we need to deal with before we move on to
There's one document I'm going to hand up, but I'll deal with that when I get to it.
All right. Now,
So this is my appeal.
Yep.
And subject to any invitation from this court to revisit matters already dealt with at the hearing of the 23rd of November, is limited to the judge's findings as to beneficial ownership of Cefn Coed.
yes, the question is survivorship.
On the basis that this court is bound by the judge's finding that the farm was not partnership property.
Yes.
My lady, I rely on PTA skeleton argument and the equivalent parts of the second skeleton argument as part of my submissions. We did seek a stay of these proceedings on an administrative basis from the Supreme Court, but ultimately the court was not prepared to entertain any application to do so, and in those circumstances, I don't make any further application this morning.
Very sensible, thank you.
I will deal first with some facts before turning to the proper approach of the court. Because even if it causes the court some difficulties of analysis, it cannot ignore the fact that there was a partnership. And I'll just let me explain that.
Yes, well, you're going to have to be very careful. I mean,
Yes.
I quite understand that your lay client has felt very strongly about the partnership aspect and has done everything he can in his power, legitimately, I hasten to add, to persuade various courts that they're his partnership point. But that's over. We're dealing only with ground 5.
This was today at least.
Well, I'm sorry, but
No, my lady, I was the only thing that was still in time to appeal, but it was a fleeting thought.
we're dealing.
Yes,
This court
yes,
is
exactly.
dealing with ground 5 and ground 5 alone against the backdrop of the findings of fact that are contained in the judge's judgment, if that's of any assistance.
Precisely, my ladyship, yes. Because, and from 1st of April 1985, Dorian and his parents entered into partnership under the name L. Williams and Son singular. Not sons, son. At the time, Lloyd was 64 years of age and was consequently 97 when he died 33 years later in 2018. On 3rd March 1986, Cefn Coed was purchased for £40,000 with a 100% mortgage from the Agricultural Mortgage Corporation, repayable over a term of 40 years with an initial interest rate of 14% per annum. In the mortgage deed, which is supplemental bundle tab 14,
Do you want us to go there?
well, it might be worth just, I think it probably is worth going there, because it's the only relevant contextual document in my submission on the question of beneficial ownership. And it's tab 14, pages 81 to 82. Dated 3rd of March 1986. The ladyship's file broken.
Sorry, just give me a moment. Years of practice, got it working again. Thank you. Yes, page 81, I have it.
Legal charge dated 3rd of March 1986, and the borrower is defined as Lloyd Williams, Catherine Irene Williams, and Lloyd Dorian Williams. See the principal sum £40,000 and the interest rate 14%.
Seems quite astonishing now, but was routine in those days.
Well, there were very serious concerns when it was purchased as whether they're going to be able to afford it. Then over the page at 82, you'll see it's a variable rate, period of 40 years, half-yearly instalments, and it's recited that the borrower has applied, that's all three jointly, have applied to AMC for a loan, and AMC has resolved to advance the principal sum on the terms of this deed. There's a covenant for repayment, and then the charge, paragraph 2, the borrower as beneficial owner hereby charges by way of legal mortgage the scheduled property with payment of the principal sum, etc. And I do rely on the statement in the deed that the borrower charged the property as beneficial owner jointly. The mortgage was recorded as a partnership debt in the partnership accounts and repaid out of partnership monies. And if one, it's probably best at this stage just to look briefly at an early set of accounts, tab 9, in the supplemental bundle, page 45. One sees in fact stated under fixed assets, Cefn Coed farm and Crythan farm. Then you have the AMC mortgage under current liabilities, which by then had been reduced to 2516. These are 1992 accounts, and by then had been reduced to 25,610.19 by the sale of a field at Crythan, which was accounted for as a partnership receipt. Then you have the capital account, joint.
I think that field was though owned by Lloyd, wasn't it? Or...
That's the judge's finding, yes.
I thought it was Lloyd and Catherine.
Lloyd, I apologise, my lord. Lloyd and Catherine, beneficial joint tenants.
There was an express declaration of trust in the
Yes.
conveyance.
Yes. And then you have capital accounts, brackets, joint. And it was always, from the outset, the capital account was stated as a joint account.
Guy, can you just point out who signed the accounts, please?
So my learned friend has asked me to point out who signed the account.
Just whilst on the page.
Well, I think my learned friend's drawn to the attention that in 1992, Mr. Tanner was,
Yes.
but by 1992, he was the accountant.
Yes.
On his evidence, he wasn't at the time of the purchase of the farm, but
Thank you.
and each of these facts appear to have been accepted by the judge in his judgment.
So each of which facts?
That the partnership borrowed the money
Yes.
and paid for the property. And core bundle tab 5. And it's paragraph 74, page 60.
I have the judgment separately, so if you would give me paragraph numbers, that would
Paragraph
be...
74.
Thank you. Thank you.
It's where the judge recorded this. Well, the fact that they were in the accounts. That's not such an important point, but then at 77, Mr. Adams points out that that was purchased by the partnership with borrowed monies and repaid out of partnership monies. The judge at that point doesn't seem to take any issue with that. And then at 79, first sentence, he says, in my judgment, the repayment out of partnership monies of the mortgage on Cefn Coed, and then he goes on to say, is a strong indication that it was a partnership asset, but then he goes on for other reasons to decide it wasn't. No.
But he does decide it wasn't.
Yeah.
Yes.
Which
So why are we looking at that?
because
What's that
this
tell
is a
us about
relevant
it?
fact. This is a relevant contextual fact to the purchase of the property, and if
Well, the relevant contextual fact, as I understand it, is that the partnership borrowed the money that purchased the farm. That's the fact, the relevant fact, isn't it?
Yes.
Yeah, thank you. And that's not in dispute. I mean, that's...
Well, it is, milady. The judge didn't find that the partnership borrowed the money. The judge found that the partnership paid the funds for repayment of the mortgage came from the partnership. That's a different thing. He didn't find that the three individuals were acting as the partnership in borrowing the money. And that would be inconsistent, I would submit, with his findings that it wasn't partnership property.
Thank you, that's clear.
And there's in particular there is a relevant fact that is contextual, that the capital account on the partnership accounts, which included in fact the capital value of both farms, is stated to be a joint account. And
The judge notes that, and you've taken us to the paragraph where he notes that that is what is said, but it doesn't go further than that is what is said.
no,
As I understand
all I'm
it.
saying, just as a matter of contextual fact,
That is what is said in the accounts.
from the outset, the partners had on the face of the accounts, I better not say, I'll be careful with my language, on the face of the accounts, the account, which includes the capital value of the farms, was stated as a joint account. And if one turns up the bundle at supplemental bundle at tab 88.
Tab 88, page 88.
Sorry, page 212 in the supplemental bundle.
Thank you.
Sorry, do your ladyships and lordship bundle have hundreds of tabs in them, or are they?
No, my tab's run out. Someone lost part at tab 10. But
That's probably. Well, I think it's probably easier to refer to the page numbers.
Luckily the printer didn't lose heart and the page numbers are there. So page
212.
212. And what document is this?
This
It's obviously a statement.
this is council's advice.
Should we be looking at
Which-
council's advice?
Well, yes, because these are documents that are disclosed by the estate, because during the questions as to the ownership of the farm arose during Lloyd's life, and acting on Gerwin and Lloyd's instructions, solicitor Sarah Llewellyn-Jones took council's advice on whether or not the property was partnership property. And also whether Gerwin had a claimant proprietary estoppel.
So why are we looking at the advice if it
Well,
deals
the
with
advice was
proprietary estoppel and partnership?
the initial advice was in paragraph 26. This is what council asked for instructions on at the time during Lloyd's lifetime. And was the farm treated as partnership assets in the accounts immediately after purchase? Yes. Do the accounts disclose that AMC mortgage taken on the farm at purchase was paid off using partnership monies? Yes. Then 26.6, they're asking what was the state of Catherine's capital account at the time, what happened to it when she died, and the answer is joint.
But
Whose
but
answers are these?
but
These are Crythan's. I'm just going to show you go on to the next.
This was nothing to do with beneficial interest. This was nothing to do with how the property was held. This was all went to partnership. And
Well, my lady, in my submission, that the contextual fact that is how the property was dealt with from the outset is relevant to the analysis of, and I'll come on to that, because if one goes, so that was what part.
I'm struggling to find that it's helpful for me to consider a council's advice that was dealing with a completely different issue.
It's only the instructions that I'm relying on, and because if one goes over just in passing, one might note that paragraph 29 is a consideration of proprietary estoppel claim. At that stage, that's Gerwin's proprietary estoppel claim, which wasn't dealt with at the trial.
Well, why are we looking at that?
Well, my lady, when we get it is relevant as to whether there's been any severance and the circumstances in
I
which.
thought the question of severance wasn't part of this appeal.
Yeah.
I thought there's been no appeal on the judge found that there was a severance.
He says that he found there was a formal notice of severance was served. That's not in dispute.
That's not in dispute.
That
If there were a joint tenancy, is it in dispute that that formal notice was effective to sever the tenancy?
yes, it was not.
Where do we find that?
Well, it wasn't pleaded or proved. The judge expressed an obiter comment that, in his view, the notice of severance was effective, but that's a mixed question of fact and law. And if my learned friend, and I'll have to develop this, but the burden on my analysis is on the respondent to prove that there was a severance. The notice of severance wasn't served in 2014, or there were two notices of severance. The order of events was Sarah Llewellyn-Jones, having consulted with Gerwin, drew up a notice of severance and took Lloyd's instructions, which he executed in 2014. But that wasn't served until mid-2015, or wasn't served until 2015. And I'll show you these documents. And it wasn't, and on the face of the documents, no instructions from Lloyd were taken before it was served. Then a further notice of severance was drawn up and sent to Susan Ham to get Lloyd to execute it. But we know nothing of the circumstances in which it was purportedly executed, and we know no attempt was made at trial to prove that document.
But was it contested? Was it in the defence?
And
where does that go
well,
for
it,
your
I can
grounds
take,
or
I can,
dealing
I
in
can,
your
I
skeleton
can take you
argument?
through the.
I mean, are you now seeking to ask this court to say there was no effective severance? And if so, where do we find that anywhere?
If it's a joint, it's a consequential question. If this court finds that the judge was wrong to find that the property was held as tenants in common, 1/3, 1/3, 1/3. And it's a mixed question of fact and law. The judge makes a one line unreasoned comment in his judgment. And in my submission, it is an issue this court will have to address.
Notwithstanding, it's not a ground of appeal and it's not dealt with in any skeleton argument that I've seen.
Well, it was only an alternative, my lady, it was only an alternative finding. And if the court will bear with me, I'll just it is important. I think my learned friend has come ready to argue for severance. He included all the relevant severance documents in the
Let's see how we go then. But
my lord, my lady, I'm hearing the position, but just looking at just going on. At the same time, counsel was giving advice on a proprietary estoppel claim. That's paragraph 29 of that advice. If one goes then over to page 216. This is a telephone attendance on Gerwin Williams, and Sarah Llewellyn-Jones is taking instructions on the question of the why the loan, which is one of the questions that was not 40,000, and he took the view that a field had been sold that a reduced. He instructed the field had been reduced, sold, and the loan reduced. the mortgage was 40 years. He refers to his £12,000 loan for the digger, and that he
I thought we were on 216.
Oh, sorry, 215. 215. I apologise. And then I think he goes on to give some instructions in relation to his proprietor estoppel claim, and whether things have been tax relief. Have been given.
This is not. This is Goen.
Yes.
He's talking to Goen.
Yes.
Yes. Thank you.
Then over the page 216 is the attendance on Kerry Tanner. Attending Kerry Tanner, who at this stage was the partnership accountant, and on the face of the documents taking his instructions from Dorian. Attending, and it was Dorian who he sent draft accounts to for their approval. Attending Kerry Tanner, checking through advice from council, check the 2013 accounts, tangible assets, etc. Cost of land and buildings is the cost of Crythan and Cefn Coed. Crythan was taken out, so the net cost of 42,000 would be the original cost of purchase and probably fees in connection with the purchase. Kerry Tanner thinks it was an interest-only mortgage with 25,000. This is consistent with his evidence that he wasn't the accountant at the time. Therefore, a payment of £15,000 would have been made at the time. Need to check with Lloyd Williams. Noted from the land registry form that the mortgage was 40,000 at the outset. Kerry Tanner confirmed the interest on the loan was always paid out of the partnership. Kerry Tanner confirmed that it's been 26,510 for very many years, and so a lump sum must have been paid off.
So what are you asking us to take from this document, where Kerry Tanner fails to give the correct information to the solicitor? What are we taking from this document?
I'm not
for
sure any
purposes of ground five?
none of that information is incorrect, my lady.
Kerry Tanner thinks it was an interest-only mortgage of 25,000. I thought it was an interest-only mortgage of 40,000.
No, it was 25,000 by that date. They're discussing why.
It's just the use of the word "was" made me think that it was the original.
I think they're just discussing at the date.
Mm-hmm.
There's then a letter to Lloyd.
But you haven't told me what we're to take from this document.
That it's confirmation that my lady, it's just confirmatory evidence that
Of what?
the mortgage was paid by the partnership.
But I think that isn't in dispute, is it? No. Thank
So
you.
my lady, then page 217 is a letter to Lloyd, care of Susan. If one looks over the page at 218, one sees that she's writing to him, care of Susan, and she's asking for instructions on why the loan's only 25,600, and there's 219. Susan replies, and these are instructions from Susan. The reference in her evidence is page 314 of the second application bundle. This is information provided by her. And
What do we take from this?
well, my lady, I'm showing you because it is part of the relevant factual matrix as to whether or not there was an effective severance of the joint tenancy.
Which bits do you rely on in that context?
Well, it's the fact that
if we accept that you're entitled to argue that.
It's that Susan Ham is giving the instructions, and that it was known that that a £40,000 mortgage had been taken out, and it had been paid off. Then over the page at 220, at the same time, was a schedule of payments that later were formed the basis of the schedule attached to the particulars of claim in respect of Gerwin's proprietary estoppel claim.
But it's not a dispute that the mortgage was repaid from partnership monies. Does this
No,
go any
no.
further than that?
Well, it does.
And I perfectly understand that you're making the point. For your point of view, a critical part of the context is the fact that the mortgage was paid from the partnership accounts, and that the three people were partners. I completely understand that, but I'm just not clear why going to various documents that simply confirm the partnership paid the money helps any further than that.
Well, it goes to the difficulty is that Sarah Llewellyn-Jenkins was in an impossible position and had put herself in an impossible position. She was taking instructions from potential beneficiaries of the estate. She was advising on a proprietary estoppel claim by Gerwin, and at the same time purporting to advising Lloyd. She had acted for Dorian as well, and you'll see from other contextual documents that the various things were being kept from Dorian, being kept secret from Dorian, and ultimately the whole course of conduct is entirely unsatisfactory, and is the sort of course of conduct that would give rise to gross suspicions as to whether a document
was this investigated at trial? I mean, if you're now saying that inappropriate, well, apart from anything else, the solicitor might want to know about the sort of allegations you now seem to be making.
Well, the trouble was that when the evidence was called, it was called on the basis that Sarah Llewellyn-Jenkins was going to be giving evidence, and these matters would have been put to her. But when it came to it, the respondents who were acting for the estate chose not to call her.
Well, you could have required, there's no property in a witness, you could have called her.
Well, she was a part. She was a party.
Yes, but she would have been given evidence as a witness. But in any event,
Right.
I mean, if where you're creeping up to in this submission, or putting the building blocks in place to say that Sarah Llewellyn was acting improperly, representing various different people where there was a conflict, and she shouldn't have been representing them all. And I understand what you've just said.
Well, it's
Although
a fact.
it's
It's a fact. I think.
It's the inferences that you're asking us to draw when it's not been put to her and it wasn't part of your case. And you're saying, so therefore, because of her impropriety, which hasn't been put to her or proved or dealt with, we have to draw the inference that therefore the severance is not a proper or honest document.
It is for the respondents to prove. A severance takes place by the communication of the true intention of the maker of the the person giving notice. The severance equity recognises that if somebody intends their share to be thereafter held in tenants in common, all they have to do is give notice of their intention, and the critical word there is intention, to the other party. And you will see in this case, for instance, that the first notice of severance was executed at the same time as a will. Now, if the circumstances in which that will were executed give rise to suspicion, then those suspicions have to be dispelled before the court can infer or conclude that.
Now, I think we do have to be very careful here, Mr. Adams, because you're on behalf of your lay client, you ran appropriately a raft of alternatives at trial: proprietary estoppel, partnership. So far as I've understood it, it's never been suggested that the will was wrongly, or that the will should have been challenged, that the will wasn't an honest will, that the will under pressure, or I'm not very sure because it's never been pleaded what precisely you're suggesting.
The will was not part of these. Was not.
No,
was
so,
not-
but what you're
But
now
part of-
saying, if the will was not properly or fair or right, then therefore the severance at about the same time is contaminated
No,
by the will.
I was saying. I was saying that, and I will. Can I come back to this? 'Cause I want to deal with it. Carefully later in my submissions. I'm saying, okay, not the will, a will. Suppose a will and a notice of
But
severance
what
are
is the
executed.
relevance of that when there's been no challenge to any of the wills in this case?
Well,
I mean, I can see that, you know, in some other case, an argument might be run, you know, here's a will, this is hugely suspicious, and therefore, you know, first instance judge, you cannot possibly rely on the notice of severance. I get that completely, but that's not this case, is it?
Well, my lady, if I can take your ladyship to the pleadings, because this is.
Thank you, that would be helpful. So we're going back to
Go back
court.
to the core bundle.
Thank you. Tab 9, I think.
Tab 9, yes. And the particulars of claim start at page 86 and 87.
Yeah.
And the whole course of conduct drawn from Sarah Llewellyn Jones' file is pleaded at considerable length.
Yes.
And all that's pleaded in relation to the notice of severance is at paragraph 52.
Sorry, just give me a moment. Please. Just
And I'm not sure this is the notice of severance that's relied upon either. But all that's pleaded is the.
I'm sorry, I was reminding myself of paragraph 17, but now go on.
52.
52.
Thank you.
So this is your pleading.
This is my pleading, yes.
So there's a positive averment that Lloyd Williams signed a form of notice of severance,
That's not in dispute.
and then you say he wasn't entitled in equity to sever it, and that's because of your proprietary estoppel clause.
That's what I say, yeah.
Yes.
But
But
the
judge having found there was no
only fact that is pleaded, which is not contentious, is that on 3rd of March 2014, he signed a notice of severance. And it's also at 51. It's also pleaded on 28th of February 2014. Mrs. Llewellyn Jones advised Lloyd Williams to give notice to sever the supposed joint tenancy. Then the if one goes on, that is then in the just in taking them in order, the first defendant deals with this at paragraph 63, page 122. It's admitted that Lloyd signed the notice of severance on 3rd of March 2014. And then in
We
the
need to look at 6.3.2 as well, don't we? It's not admitted that the equitable interests had been held under a joint tenancy.
no, that's right. Then if one goes on to the I think it's the second defendant deals.
Well,
in
63.6,
Yes.
so should we not look at that as well? If the actual interests were held under joint tenancy, it's denied that he was not entitled to sever or that it was inequitable to sever. There was nothing inequitable in Lloyd taking a step, etc., etc.
There's no positive pleading of a severance there.
No, but both parties are proceeding on the assumption that Lloyd did sign the notice severing the tenancy. Your case is he wasn't entitled in equity to do that, and that's answered by saying, yes, he was entitled in equity to do that. Neither side is suggesting that although he signed it, he didn't mean to sign it, or he didn't give it to the remember that it wasn't effective for any other reason to sever it. It just isn't raised as an issue on these
Well-
pleadings, which is
Well,
what we've seen so far.
and my lord, in my submission, and it wasn't an issue that was gone into a trial. And in my submission, the reason for that is that this wasn't an issue that was the forefront of anybody's minds at trial. And there isn't actually, if anybody positively pleaded a severance, then it would have been undoubtedly dealt with in the pleadings. Because
But you did. I'm so sorry to interrupt, but as I understood it, in your I'm so sorry to have interrupted. In your particulars of claim, at paragraph 52, you were asserting it and then saying it wasn't effective or it was because it was unconscionable, etc. But you assert it, don't you?
In my submission, the wording is careful in that he signed a form of notice of severance. There's no dispute about that.
So all hands on use of form of notice.
Yes.
Mm.
And all that's said in the defence and counterclaim of the third defendants is paragraph 31, page 163. It is admitted that the deceased executed the notice of severance of tenancy on 3rd of March and executed a new will on the same date. And the remainder, and I think it's also in respect of paragraph 51, paragraph 30, it is admitted that on 28th February 2014, Mrs. Llewellyn Jones advised the deceased to give notice to sever the joint tenancy. But it wasn't in fact done at that time. And there is no pleading as to what notice it is claimed was effective and to sever the tenancy and when it was given. There's no notices of severance were served until well into 2015, which is something I will come back to in the factual context. If and I fully accept this was not something that was canvassed by either party at trial.
But it's not a ground of appeal either. The issue that it has never been suggested, so far as I understand it, that there was not an effective severance.
But
And now, for the first time in oral submissions, have you given notice? Have you that you've changed your approach, or you've not sought to amend your grounds of appeal?
Well, my lady, my submission, it isn't a ground of appeal because the judge didn't find there was a joint tenancy that was severed. It's no part of his decision that there was a joint tenancy that was severed. His decision was, which is appealed, is that it was and he only expresses a view in his judgment. The appeal is against the finding that it was a tenancy in common. If that appeal is successful, that leads to a consequential question as to whether or not, if it was a joint tenancy, it was severed.
Yes.
Yes, and the judge expresses, he says, in my judgment, if it were a joint tenancy, then it was severed.
Yes.
And that's a mixed question of fact and law.
Well, I understand that on his primary finding it doesn't actually arise, but he says it's a tenancy in common, but if I'm wrong about that and it's a joint tenancy, then in my judgment it was severed. That's what he finds. You appeal and say he is wrong about that, it wasn't a tenancy in common, it is a joint tenancy. Do you not also have to say and his contingent finding that if it were a joint tenancy, it had been severed, don't you also have to say that that's wrong somewhere before coming into the court?
Well, my lord, if it's an issue that has never been decided and never properly been addressed by the parties, and it hasn't been pleaded, it wasn't fully argued at trial, and there was no reasoned determination of it.
But
Either this court is going to have to take a view in my submission, or it's going to have to go back to a judge.
I mean, you say
Considering this issue.
nobody focused on this at trial. One of the things the third respondents asked the court to determine, looking at paragraph 39 of their counterclaim, is whether the deceased, this is 39.4, owned any beneficial interest in Cefn Coed Farm. So, although nobody seems to have addressed it in terms in the pleadings, and nobody seems to have addressed it at any length at trial, it was an issue for the judge as to what the deceased, Lloyd's, beneficial interest in Cefn Coed was at the time of his death. And he gives an answer to that, which is he had an interest in common, so he had a 1/3 interest of his own, and he also inherited his wife's 1/3 interest. That's the answer. But he also says, if I'm wrong about that, and it was a joint tenancy, then it was severed. Now, and it follows from that, I don't think this is disputed, that his fallback finding would lead to the answer to this question being he had a 1/2 interest at the time of his death. If you wanted to say, no, A, it was a joint tenancy, and B, it was never actually severed, so that he had no interest at the time of his death, do you not have to say that in your pleadings or in evidence at trial or in submissions at trial or somewhere? Because otherwise, this question of what beneficial interest Lloyd had in Cefn Coed at the time of his death would be left unanswered. And as you say, it would have to be answered in a second trial, and that doesn't seem at all.
Well, that might have to be. It was perhaps unfortunate that so many issues were tried to be dealt with at the same trial anyway, because there was a sort of logical sequence to them as to Gerwin was party to one, Susan was party to
Well,
another.
speaking for myself, I think trying everything once rather than twice, it seems entirely sensible. But there we are. I mean, the question is not, did the judge make a sensible case management decision? The question is, what did the judge decide and what was in play before him? And at the moment, I find it difficult to accept that the question of severance, even though not raised, wasn't something that he was entitled to deal with, given the counterclaim of the third respondent and the evident intent of the judge to try and resolve everything. What you're submitting to us is that the question of severance simply wasn't really an issue, and I have difficulty with that.
I suppose in res judicata terms, it was never distinctly put in issue. It wasn't fully argued at trial, and the judge expressed a view on it in his judgment.
Was it not for you to say somewhere, you can't just jump from the conclusion there's a joint tenancy to it having been severed, because quite apart from my proprietary estoppel argument that it would be unconscionable for Lloyd to sever it, I've got another argument which is he never actually did it.
Well, my lord, could I just hand out one further document which I was going to hand up anyway?
Yes.
Just while that's been handed up, it's looking at paragraph 84, which is the relevant paragraph in the judge actually doesn't say, but if I'm wrong about that, what he says is, in any event, and he makes a finding. The notice of severance was, in my judgment, effective to sever any joint tenancy. Thank you very much. And you're now seeking to go back behind that finding of fact, are you?
Which isn't a finding of fact, it's a mixed finding, which is why he expresses it as a judgment, I suspect. it's a in advance of the trial, we made it clear that we were not accepting that any documents after 2007 from Lloyd had any evidential value.
And where
Because
do
of
we
his-
see,
because
where do we
of his-
see where do we see that dealt with? Just take us to the paragraph in the judgment. Just
it isn't dealt with.
and was that your case at trial?
Well, our case was that and this was what you do see is with the statement that's dated 8th of October 2014, because that's a very problematic document, and we did not accept that was admissible at trial of as hearsay evidence of what Lloyd. But I was careful to only rely on the omission that the judge refers to, contained in that document, because it was always, we made it clear from the outset that we were not accepting that anything that Lloyd did in this period was effectively of his own volition.
Was there evidence before the judge, witness evidence about the state of Lloyd's mind at particular times?
There was in the bundle a doctor's report, I think obtained in 2016, saying he had slow onset dementia.
Yes, and did that was that played out before the judge in the sense that was the medical person called? Did any other witnesses deal with what they perceived to be the capacity or lack of capacity? No.
Well, there was one. Gerwin expressed in evidence his view of his father's capacity, which I think was accepted by the judge.
How do we know it's accepted?
And my lady, I think that is mentioned in the judgment.
Right, thank you.
I'll find the passage. But this goes. The importance of this depends on where the burden of proof is when we get to notice of severance. And if I can come back to this, because
well, you've handed this in, so I'd
can
just
it
like
go
to.
in supplemental bundle?
No, but I'd like to cross-reference it to the judgment, because presumably you are saying that this was your case, and therefore the judge, in dealing with the evidence and his findings, would have dealt with it if it was part of your case in the course of the trial.
Do we have your closing submissions at trial, Mr. Adams?
They were oral. There isn't a
There were
transcript.
no
I don't think we've got a transcript. I can try and find out if we got a transcript. I very much doubt that this point was
So
covered.
there are no written submissions.
No.
I think there were written submissions from the respondent.
There were written submissions by way of skeleton arguments, and I've actually got copies which I've referred to in my skeleton argument of this appeal, and I understand it's not opposed that they should come in.
Was that a skeleton opening, as it were? or-
Skeleton opening.
Opening,
Yes.
yes. Did you have a skeleton opening?
I've got a copy of Mr. Adams.
Mr. Adams.
He's
For
just-
trial? Did you have a written opening, a written skeleton opening for trial?
Yes, I did. Yeah.
We don't have that, do we?
I've brought copies
Of
of
both.
his
Both sides.
and mine. Yes.
Oh, that's most helpful, thank you.
I can hand them up now if it would assist the court.
Yes, I think we probably ought to. Since we've started on a discussion what was and what wasn't.
And if I could just say, paragraph 50 of the judgment says, in May of that year, Mr. Williams was chiefly diagnosed with slow onset of Alzheimer's disease, but assessed him as then having sufficient capacity to understand his estate and to decide upon its distribution. And
That's very helpful.
Thank you. That was probably the passage you were looking for.
Probably is.
Sorry. There's, two documents for each.
My lady, I think we've gone somewhat off course, and I will come back to this.
Well, at the moment, we've had an hour on severance, which wasn't pleaded, so I am very concerned that we do move on to.
Yes.
I mean, this is,
So I was in the supplemental bundle at page page 220, and then at 222, following, there are solicitors' further instructions to counsel on the basis of what she had, of the information she gathered. She says, bottom of 26.1, well, 26.1, she explains that the 42,556 represents the original purchase price of Cefn Coed, plus some costs on acquisition. A field was sold. No one really knows how the rent was paid, 1st of April 85 until the acquisition of Cefn Coed. In fact, the reference is AB2, page 352, because the partnership did pay the rent for Cefn Coed before it was purchased.
And that's accepted, I think.
Yes. And of course, the property was then purchased with a very substantial discount because of the sitting tenancy, which was...
May I just clarify that point? And the judge found that the partnership had been formed on the 1st of April 1985, because that's what it said in the deed. That was a fact. I put forward a different case that actually the partnership would have been formed later in 1986 at the time of the mortgage, which he didn't accept. I haven't sought to appeal his finding of fact because it hasn't been necessary for me to do so on the basis of the issues which I understood to be before the court. So you're right that if the partnership was formed on that date, then it was the party paying the rent. If it wasn't formed, then it can't have been.
Thank
Well,
you.
there is a cash book kept, which I think is title partnership, and that's the page reference.
It doesn't distinguish between the business. It's Catherine's cash book, which she just kept, and we had the cash book going back many years from before the date of the formation of the partnership, and it was just the same document, a notebook which she kept in her own hand.
Then, most importantly for present purposes, 26.6. This principally goes to joint or tenants in common. No separate capital account was ever created, and the capital account was always a joint account between the three partners. So her instructions on behalf of Lloyd during his lifetime were that
now where have we got to?
if we put that away now.
Just before we leave that, this question of the capital being shown as a joint account, does that necessarily imply the same as a joint tenancy of land? In other words, survivorship? Does it simply mean that the partners did not distinguish their respective shares in the capital? They identified, the accountants identified what the capital of the firm was, but the partners didn't go any further and identify their individual interests in the capital of the firm, which is a different question from the question of survivorship.
My lord, when we, and I haven't started on the principles, but in my submission, whether or not the court can infer a tenancy in common will depend on whether it can infer the intention was separate or communal.
Right.
And the fact that it is a joint account stated in their communal business as a joint account, in my submission, will be that that's strong contextual evidence
Yes.
for
see
it
where you
being
put it.
a joint tenancy.
I see. Thank you.
I've given you the reference. I think I've given you the reference for the fact that the partnership paid the rent. My learned friend can't now go behind the judge's finding. That,
Well, he just told us he couldn't.
and there's an entry for the rent pre-purchase of Cefn Coed in the cash book. And there's also early evidence that the partnership paid the mortgage. That's page 357 in AB2. Judge also found that Mr. Williams' recollection recorded in the document dated 8th of October 2014 was accurate. This is the representation that was made to Dorian at the time of purchase. And that does require a little bit of unpicking to construe what the judge was saying.
Where is that in the judgment?
24 and paragraphs 24 and 25.
Thank you.
What he says in paragraph 24 he says in October 2014, in fact the documents show it cannot have been in October 2014. Mr. Williams made a written declaration saying that he recalled during the 1980s we did mention to Dorian he would inherit the farm if Gerwin was running the contracting business. He said he must be careful relying on tested statements, and this is the passage I relied on as an admission. And he says the evidence suggests, despite his age, Mr. Williams remained physically and mentally well until his diagnosis in 27. So that's another finding in relation to. Moreover, some support for this was given by the witness evidence. And there was a conversation in 1988 that Mr. Williams was going to leave Cefn Coed to Dorian. When this chap's father said that Mr. Williams had two sons, the latter replied that Dorian was the father and the other was on the motorways. In my judgment, it's likely that Mr. Williams did mention this to Dorian as he recalls, but when Gerwin was working on the motorways, in my judgment, it's likely that the recollection of what Mr. Williams said to Dorian at the time about inheritance was accurate. Now, to unpick what he meant by at the time, one has to then go to the document that is dated 8th of October 2014. And one starts in the supplemental bundle at page 260. This is a copy of a letter dated 8th of October 2014. So presumably put in the post on 8th of October 2014. I have pleasure in closing a copy of the will that you've now executed. This was immediately following the execution of a will, together with a statement of our discussion. Please will you check the statement very carefully to make sure that you are happy with it, make any amendments that are required, and return it to me for reprinting. I'll then send it back to you for signature. And that document was sent care of Susan Hann. Now, we know it wasn't returned, at least initially, because if one goes on to 263, there's a letter to Gerwin, 13th of March 2015. I attach a copy of the letter which I sent to your father on 8th October together with the statement that I prepared for him. I'm concerned that he has not signed it. Please could you arrange for him to sign it and return it to me? Now, Gerwin, I did ask Gerwin in his evidence about the circumstances in which this document was signed, but he was unable to give any evidence as to how it came to be signed. And the reference in the transcript is at application bundle 2, page 272, at C to G. One then goes, we do know it was signed because it was produced by Sarah Llewellyn Jones from her file, but when or how, we have no idea. And again, it was something that she could have dealt with in evidence if she'd been called. And in my submission, this was a dispute between the Dorian and the estate, and it was for the estate to call the evidence it needed to prove the matters it relied on. And this document, it's very confused. The chronology is completely wrong. He starts off at the bottom of the page, or this is a document we do know was prepared by Sarah Llewellyn Jones following a discussion with Lloyd. In or about 84.
I've now lost it. Which page are we on?
265.
Thank you very much.
And it's at the top of 266 that we get the solicitor's
Yes.
version of what she says was discussed, let's put it that way,
Yes.
About the position in relation to Cefn Coed, why it was put in 3 names, and what was said at that time to Dorian.
Well, if we start at the bottom of 265, you see, in about 84, 85, my son Gerwin decided to start a contracting business. Now, he didn't start the contracting business until about 1992, I think. He continued to live at Cefn Coed and ran the business from Cefn Coed. That was the later business. Despite the fact he had a contracting business, he always worked on the land, particularly doing contracting work such as drainage and general farm work. The judge found that even though Gerwin was off the farm when he was doing the motorway work, and then spent some time building a house and developing a plot in 91, 92, then started the contracting business, which he ran until 2010 as a full-time business. In his spare time, he was still doing work on the farm. On 3rd of March 96, my son Lloyd Dorian Williams and I purchased Cefn Coed. I recall the property was purchased in our 3 names because AMC insisted that not only was the property purchased in my way and my wife, but also my son's name because he was younger. At that time, we decided to put the farm in the name of Dorian and not Gerwin because Gerwin had started the contracting business. In those early days, I recall we did mention to Dorian that he would inherit the farm. And then he says, if Gerwin was running the business, and it's anybody's guess by what is meant by if Gerwin was running the business. And this is what the judge found is an accurate record of what was said at the time.
And your grounds of appeal don't go to that finding.
Well, the important point I rely on is that it is part of the factual context when the farm was purchased, and this is the judge's finding, that Dorian was told he would inherit the farm.
Yeah,
And
so
the
that's back to
judge
24 and
has made that finding.
Yeah, that's at 24 and 25.
Yes.
Yes.
Then we have to put that against paragraphs 59 onwards.
The judge affirms later that that is his finding.
No, but the judge then goes on and said that didn't continue to be the position.
It will be my submission that the only time that counts is when the property was purchased, and I will get on to the law in a moment.
Well,
I'm saying the context at the time of the purchase, which is when it would have been determined whether or not it was a joint tenancy or tenants in common, was that Dorian had been promised he would inherit the farm. And I say
But
that
that's
that strong
proprietary
contextual
Aristotle, and you
evidence.
lost on that.
No. Well, my lady, yes, of course I've lost on proprietary estoppel. That doesn't affect the fact that this is a contemporaneous statement that is part of the factual matrix, that is the context in which this court has to determine whether or not it's a joint tenancy or a tenancy in common.
But you've taken us to those notes, and for example, page 266, which you say the judge accepted, where it's also said at the top of page 266, we purchased this in 3 names because that's what the mortgage, or AMC anyhow, insisted on. And so that's why it went into those 3 names.
In my submission, the judge was very careful as to what he accepted from the statement, because he cannot have accepted it all. Because if you see, you go on.
Well, that's why you just said he accepted what we've just looked at, and that's why I'm concerned to determine precisely what he accepted.
Well, that's what he says at 24 and 25.
Yeah.
And it's the bit in quotes at 24. We did mention to Dorian he would inherit the farm.
Right.
And I'm saying that is, and I was going through this because at the time that reflects the language in the paragraph before in this statement. At that time, we decided to put the farm in the name of Dorian, and the time of the time that the statement was made was at the time of the purchase. Therefore, it is an important element in the factual context in which the farm was purchased.
Why does the statement that Dorian will inherit the farm assist on the question of survivorship? Because there's no, I mean, Lloyd was a farmer, he wasn't a lawyer. How can you derive from a statement that you will inherit any inference as to whether Lloyd thought that what would happen is that the farm being taken in joint names would be held jointly beneficially, and so it would accrue to him by survivorship as long as he was a survivor, which is he was likely to be given their respective ages, or whether what Lloyd thought was that they were taking them in common, and that he and his wife, in due course, would leave it to Dorian in their wills. It either is a way in which Dorian ends up with the farm. Why does the statement that you'll inherit the farm one day assist us in understanding the intention which we have to grapple with, which is, was it intended to be joint or beneficial? For my part, I don't see that it really sheds any light on that question at all. Indeed, if one was being entirely technical about it, in a joint tenancy, one doesn't inherit. It accrues. Now, I'm not suggesting for one moment that when Lloyd said inherit, he was aware of the technicalities. My point is that saying you'll get the farm one day doesn't, to my mind, cast any light on the legal mechanism by which Lloyd thought that would happen.
And it was Dorian's evidence that his father said all you've got to do is pay for it. And the reason it is relevant is this question of whether this is a communal family enterprise or whether this is a separate commercial arrangement where the parties are dealing with their shares separately. And in my submission, it reinforces the presumption that, well, not the presumption, reinforces the legal position rather than detracts from it.
Thank you.
At the time, and this is also relevant, at the time, Gowan had left the farm in 1982, which was about to work on the motorways, returning only evenings and weekends. And in cross-examination, this is AB1 tab 9, page 275, he said he was courting at the time, that was around 82, I started courting, needed money, nights out, sort of things like that. Never went on holidays and went out the farm to earn some money. And I earned tidy money. I didn't go and work for the local authority. That's what Dorian had done previously. A couple of £100 a week. When I went out to earn money, I earned tidy money. And he is, and I understand it remains, a successful businessman. We were told after the last hearing that he's still registered for that. And
So what's this?
Well,
what's the relevance of this?
the relevant for the context is that when Gerwin had left the farm, he'd went out the farm to earn money elsewhere at the time Cefn Coed was purchased. The landlord, no doubt, a commercial landlord bought the farm. He reviewed the rent, and it went up from about £100 to about £1,500. He served as schedule of dilapidations. It was very hard work to maintain the tenancy. It was Dorian that stayed on the farm to work the farm. Gerwin, for perfectly understandable reasons, wanted more money, and in his words, went out the farm.
Still working on the farm evening and weekends.
Yes. So that's basically all the context we have as the circumstances in which the farm was purchased.
What you've just said explains, as indeed the statement drafted for Lloyd and signed by him says, that at the time we put Dorian on the title and not Gerwin because Gerwin was working elsewhere. He says contracting. Judge says, I think he meant when he was on the motorways. Well, that I understand all that. That explains why the three names are the parents and Dorian and not the parents and Gerwin or the parents and Dorian and Gerwin. Does it assist with the question we have to answer, which is, were the three of them joint tenants or tenants in common? Because as I understand it, it's never been disputed that if they were tenants in common, they were tenants in common in equal share. So it's never been disputed that Dorian was effectively given a third of the farm. The question is whether that was a third share held as part of a joint tenancy or a third share held in common. And I don't, for myself, see that there's the fact that Gerwin wasn't included in that arrangement because he was working elsewhere. Again, I don't see that it sheds any light on that question.
Well, my lord, I was going to turn to the principles and I'll deal with them as shortly as I can. And in my submission it does, because it goes to the critical question as to whether this was a communal enterprise or a separate commercial enterprise. And it was this is a family farm where Dorian is expected to inherit. He is taken into the business, he's taken into the partnership, and this is a joint family enterprise. Parents were coming up to retirement age. They weren't expecting to even live to see the farm purchase, the mortgage paid off. This was a communal family enterprise. And I'm going to say, dealing with points of principle, first point is that as there's no express declaration of trust, equity will follow the law unless that conclusion is displaced by an objectively deduced common intention or a contextual inference or presumption that the ownership was not intended to be communal, but rather separate. Secondly, there's then a question as to what evidence is admissible in order to objectively determine the parties' intentions at the time of purchase. Thirdly, and I'll turn to the evidence to show there is no evidence to rebut the starting point that equity follows the law, so that the property was held jointly. Rather, the context strongly reinforced that conclusion in a like manner to the domestic context, as in cases such as Cefn Coed and Jones and Coed. And then I'll come back to Severance.
You're a brave man.
The first point is that as there was no express declaration of trust, equity will follow the law. And I say this is unless displaced. Lord Walker and Baroness Hale in Jones and Coed, and it's at paragraph 19, stated and it might be worth turning up, Jones, straight away. I'm afraid the bundle is named as my authorities, in fact it's a complaint. It's tab 7. And what Lord Walker and Baroness Hale in their joint judgment say, and they're talking here in the domestic context, is that the presumption of a beneficial joint tenant, paragraph 19,
Thank you.
page 4 of the judgment. So the presumption of beneficial joint tenancy, and I would here insert the words in the domestic context, is not based on a mantra as to equity following the law, though many non-lawyers would find it hard to understand the notion that equity might do anything else. There are two more substantial reasons. First, just below E, the first is implicit in the nature of the enterprise. If a couple are in an intimate relationship, decide to buy a house or a flat in which to live together, almost always with the help of a mortgage for which they are jointly and severally liable, that is on the face of things a strong indication of emotional and economic commitment to a joint enterprise. And I place some emphasis on the words joint enterprise. The second reason, one then cites some of the authority, and 21, he refers to an article of Gardner and Davidson. The context under discussion is one which people will not normally formulate agreements, but this is crucial. The very reason for this, the parties' familial trust is in one another, also warrants the law's intervention nonetheless. Unless the law reacts to such trust as much as to more individualistic forms of interaction, those who put their faith in the former rather than the latter will find their interest thereby exposed. Gardner has termed this a materially communal relationship, i.e. one, in practical terms, they pool their material resources, including money, other assets, and labour. And 22, the notion that in a trusting personal relationship, the parties do not hold each other to account financially is underpinned by the practical difficulty in many cases of taking any such account. Perhaps after 20 years or more of the ups and downs of living together as an unmarried couple. That is the second reason for caution before going to law in order to displace. So in this sense, in a domestic context, it positively reinforces, the presumption positively reinforces the position in law, and is in that sense an evidential overlay on the legal position. It is, however, in my submission, still a second step in the analysis that either to some extent displaces or in the domestic context reinforces the starting point that equity follows the law. And the reason is it's not just a mantra, rather it's a matter of jurisdiction. The underlying principle is that a court of equity can only exercise its jurisdiction to prevent the legal owner relying on their legal rights if to do so would be unconscionable and result in an injustice. That can only ever be its justification for intervention. Otherwise, the parties' relationship will be governed by the applicable rules of law. Equity, however, readily recognises that people generally do not give away their property, except to certain persons with whom they have close personal relations. Rather, generally, equity follows or traces persons' property through a transaction into its proceeds or substitute. Consequently, generally, unless there's a family context that dictates otherwise, if property is purchased using monies contributed in unequal shares, then equity will readily presume a resulting trust. And if one turns to McGarry and Wade for the relevant presumptions, this is tab 1, 12022. Taking the sentences, first two sentences in reverse order, if their contributions are unequal, the purchasers are presumed to take beneficially as tenants in common in shares proportionate to the sums advanced. That is the presumption of resulting trust, which is why generally who paid for the property is critical. Something may cause a slight difficulty of analysis in this case. If, taking the first sentence though, if two or more persons together purchase property and provide the money in equal shares, they are presumed in equity to be joint tenants. Such a presumption is not a rule of law. Rather, the imputation of an intention as a matter of fact reflects no more than a consensus of judicial opinion disclosed by reported cases as to the most likely inference of fact in the absence of evidence to the contrary. And I get that from a passage in Pettit and Pettit, recently followed by Lord Justice Lewison in the case of Volpe. It's paragraphs 45 to 46 in Volpe, but if one turns up the original passage in Pettit and Pettit, which is tab 2, and the passage is 823G, this is Lord Diplock and Pettit and Pettit talking about the process of imputation. Similar technique is applied in imputing an intention to a person whenever the situation with which an act is done affects its legal consequences, and the evidence does not disclose what was the actual intention with which he did it. Situation commonly occurs when the act is deceased. When the act is of a kind to which this technique is frequently to be applied by the courts, the imputed intention may acquire the description of a presumption. But presumptions of this type are not immutable. A presumption of fact is no more than a consensus of judicial opinion disclosed by reported cases, the most likely inferences of fact to be drawn in the absence of any evidence to the contrary. For example, presumptions of legitimacy, death, survival, and the like. The most likely inference to a person's intention in the transactions of his everyday life depends on the social environment in which he lives and the common habits of thought of those who live in it. And then he explains how the consensus of judicial opinion must change with changing times. And therefore, these are not rules of law set in stone, but guides to how the court approaches inferences of intention. And presumptions will rarely be, which are of assistance, are rarely likely to be decisive. There's a case in the Privy Council case of Marr and Colley. There's a passage at paragraphs 53 to 54, which I think is of some assistance. Because in that case, it was suggested that there was a clash of presumptions, and it was a question. There was a lot of arguments to which presumption would win, and 54 in particular, the board considers that, say perhaps where there's no evidence from which the parties' intentions can be identified, the answer is not to be provided by the triumph of one presumption over another. In this, as in so many areas of law, context counts for, if not everything, a lot. Context here is set by the parties' common intention or by the lack of it. And if it's the unambiguous mutual wish of the parties contributing in unequal shares to the purchase of property, that joint beneficial ownership should reflect their joint legal ownership, then effect has to be given to that wish. If, on the other hand, it's not their wish, then ultimately the resulting trust solution may provide the answer. And that's because the court is concerned to establish the parties' intentions at the time of purchase, or possibly in a domestic context at some later date. The approach to such questions of intention was examined at length in the domestic context in Jones and Kernet. And if we just go back to goes to Jones and Kernet at tab 7, and one finds the summary. I think that there are passages dealing with inference or imputation, paragraphs 26 following. Dealing with the imputation. Paragraph 31 is not marked, but I'd also draw attention to it. And they make reference to the classic resulting trust. And there are two situations: A, where resulting trust will arrive, and two, it's clear the beneficial interests are to be shared, but it's impossible to define a common intention to the proportions in which they're to be shared, and the court may be driven to impute an intention. Paragraph 34.
I think we just need to look at 31, don't we? Resulting
Well,
trust
yes, there's a reference to pet.
be rare in domestic context, but might perhaps arise where domestic partners are also business partners.
Yes, that's referring to the resulting trust assumption. So that's unequal.
Yeah.
If there are unequal contributions.
But of course, yes, because most of the cases are about cohabitees that fall out, and so the question is not survivorship, but rather the equality or otherwise of the shares in the property.
They may well, and that's essentially the sort of second
which
question.
That the reason I was looking noted that though is that the Supreme Court identified that there may be a different situation when looking at this overall topic, where you've got domestic partners, also business partners, which I'd just be interested in your submissions where we're talking about a farm where they also lived and worked.
Yes, well, I'll be saying that falls the communal side of the line, not the separate side of the line, and I'll develop that submission with reference to the other.
So my highlighting that was merely to show that that was in their mind, that might be a slightly different category.
Well, I think they were. I think that was with deference to Lord Newburgh. I think Lord Newburgh was very worried that the principles of resulting trust in a commercial context would go out the
He
window
was.
in the light of Stack of
Very
Doubt.
worried.
And they were reassuring. You know, that is a different situation, and it arises where there are unequal contributions.
But the point, which is, I think, being made by you and by my lady, Lady Justice Black, is you're saying this is a family. I'm so sorry. Okay, is a you're saying this is the context here is familial and communal, whereas the point that Lady Justice King was making was because she was picking up on that paragraph, which does refer back to resulting trust, is context is everything, and it depends whether the context is or isn't a domestic one, or it is a commercial one, and in this case is a mixture of both. And I just, before you go on, and I'm sure you'll pick it up, mention that at paragraph 69 of Stack and Dowden, it's talking about context is everything, and it's saying the domestic context is very different from the commercial world. So you don't need to go there now, but that is the thread that my Lady Justice King was teasing out, and I think it's the one that you say, aha, but this is a communal, familial context.
I think this goes back to my point that you have the legal position,
Yep.
and the context may reinforce that legal position and make it harder to displace the legal position, or it may make it easier to displace the legal position. And the more commercial you get, the more the parties are looking to their own separate individual interests, then the more likely you are for it to detract from to start to draw inferences away from joint property. And there are some commercial cases which I'll come on to. Sorry, I was just going. Paragraph 34 was where I was going.
I'm so sorry, you're in Jones and Kerner.
Jones and Kerner, paragraph 34, yeah.
Yes.
And they're saying how the difference between inferring and imputing is clear. In inferring, there was some actual common intention which you're deducing. Imputing, there was no actual common intention, so your courts may have to substitute something for them. The law recognised that legitimate inference may not correspond to an individual's subjective state of mind. And there's a passage, cite a passage from Gissing, which I do particularly write on, as in so many branches of English law in which legal rights and obligations depend on the intentions of the parties to a transaction. The relevant intention of each party is the intention which was reasonably understood by the other party to be manifested by that party's words or conduct, notwithstanding he did not consciously formulate that intention in his own mind, or even acted with some different intention which he did not communicate to the other party. And then that point was developed by Nick Pisker in an article on Stack and Dowden, which they cite. Subjective intentions can never be accessed directly, so the court must always direct itself to the consideration of the party's objective intentions through a careful consideration of the relevant facts. I emphasise relevant facts. The point is that the imputation inference distinction may well be a distinction without a difference with regard to the process of determining parties' intentions. It is not that the party's subjective intentions are irrelevant, but rather that a finding as to subjective intention can only be made on an objective basis. And I emphasise that the question of intention is always an objective one. And generally, the intention with which one is concerned is at the date of acquisition. There is a document in this case. There is a transfer into the parties' joint names. The question that the court is looking at is the intention of the parties to put the property in joint names. And unless one can infer that they didn't intend the ownership of the property to be settled at that date, one's looking at the context at the date of acquisition. And as a matter of principle, the only relevant evidence will generally be the admissible factual matrix for the transaction and documents which objectively inform the context of the instrument in question. And it's slightly off away from the subject, but I do rely on the discussion in Wong and Gran view at paragraph 63 as to what evidence was admissible to draw inferences as to the intention of a power in a trust instrument, because in a sense that's a similar problem. Instrument is silent, and one's looking to determine what evidence is admissible to draw an objective conclusion as to what the intention was, whether you call that as a matter of construction of the document, which is silent, or or independent of the document. It matters not. In each case, the court is concerned with identifying the intention.
Did you say paragraph 63?
63, yes. It's page 652, I think it is.
Just give us a moment and we'll just read that paragraph. You.
And the point I draw from that is it's the context at the time. What is the subjective understanding that a party may have later will generally be irrelevant and positively dangerous, not principally for the reason given in Gissing, that this is an objective question. What they understood the position to be may well be neither here nor there. And the question for a court of equity is always whether it can conclude that the intention must, and I emphasise the word must, because have been something other than the joint beneficial ownership. And I emphasise the word must because courts of equity shouldn't intervene in the legal relationship unless confident that if they didn't intervene, it would produce an unconscionable result. Now, that may be relatively easy if in a sort of commercial context where one party's paid for the whole property, they put it in joint names, and they then die. So in certain contexts, that may be relatively easy for a court to conclude that it would be unconscionable for the equity for the beneficial ownership to follow the law. In others, it will be much harder to displace the legal position, and we've already looked at the domestic context where the context will actually reinforce the legal position. And so the burden will always be on the person seeking to engage the court's equitable jurisdiction to prevent reliance on the legal position, if only to prove that in the context some other intention is to be inferred or imputed. And in this case, the respondents, and it is notable, did not put forward any positive case whatsoever. So, in my submission, the questions are, firstly, whether the context leads to the presumption or inference that beneficial ownership was not intended, because that sort of shifts the burden one way or the other. Secondly, whether there was any express agreement that displaced any such inference or presumption, or otherwise proved the party's actual intention. And thirdly, one might get on to conduct, but that has to be pretty extreme if the court's going to infer that an intention from it. And there's no suggestion that of either an express, in this case, there's no conduct which would lead to such a conclusion, or it's not alleged there is. The judge's finding on this can be found paragraph 84 of his judgment. And all he says is, in the absence of any declaration of the beneficial interests of Cefn Coed, the purchase of it for business purposes and Mr. and Mrs. Williams' treatment of their shares as separate suggests a tenancy in common. And he declared that it was a tenancy in common in his order, which is at page 71 of the core bundle. One is the contextual reasons. He says business purposes, which is not a recognised presumption, but I think he sort of tied up sort of concept in that this was some sort of commercial arrangement.
You say it's not a recognised presumption. I thought it was a recognised presumption that survivorship, equity didn't like survivorship in commercial contexts.
I think equity, and I think I've already made this submission, equity in a commercial context will readily assume parties were looking to their separate interests, not enterprise. That is, in a sense, that's not any sort of presumption. It's just recognising that in a commercial context, parties will generally be looking to their separate interests.
Well, that's you took us to McGarry and Wade, isn't it? Where partners acquire land as part of their partnership, as they're presumed to hold as beneficial tenants in common. It was an ancient rule that the right of survivorship has no place in business. And that's
yes, and that's because if one invests property in a partnership, that is a presumption. That's a recognised presumption.
Yeah.
And I'll there are. Sorry,
I was talking more the ancient rule.
Well, that's a partnership rule, and that is recognised. And there are two cases that perhaps I should have taken you to as well, which is which I think case is particularly relied on my learning from. There's Lasker and Lasker, tab 4, which is all these cases turn on their own facts, but this was mother and daughter jointly buying a council house as an investment. So they were not buying it for any sort of communal purpose. They were to live in, or as for any sort of family purpose. They were buying it as an investment. And at paragraph 17, it was argued that this case was midway between cohabitation cases of co-ownership where property is bought for living in, such as stack, and arm's length commercial cases of co-ownership where property is bought for development or letting. In the latter case, the reasoning in stack would not be appropriate, and the resulting trust presumption still appears to apply. In this case, the primary purpose of the purchase was an investment, not as a home. In other words, this was a purchase that was at least primarily was not in the domestic consumer context, but in a commercial context. To my mind, it would not be right to apply the reasoning of stack and down to such a case as this, where the parties primarily purchase the property as an investment for rental income and capital appreciation, even where with the relationship is a familial one. Now that is, you do not, so Lord Newberger saying in Lasker, you don't apply a positive presumption of joint tenancy, because this was nothing to do with their domestic arrangements. So ordinary presumptions arise, and that would be a presumption of resulting trust if they contributed unequally. if they contributed equally, it would still be a presumption of resulting trust. Let me be the presumption of joint tenancy. And I think I've already taken you to the passages on context is everything. It may be somewhere else in my submissions. I'll come back to it. I'm conscious of the time.
Yes, you will be finished before the short adjournment, won't you?
My lady, yes. So the reasons just given, Catherine and Lloyd's later understanding of what their ownership was is irrelevant, and so for that matter is that of Dorian. And the learned judge was respectfully wrong to place any reliance on Lloyd and Catherine's later treatment of their shares as a matter of principle. It's not clear.
Can I just be sure I understand what you're saying there? We understand that in a contract, you construe a contract by reference to the factual metrics of the time. What people later say they meant has very little weight. But that's because it's a document which has to be construed objectively. This is a slightly different question. It's not a question of construction. This is a question of what was the party's intentions. Now, I understand your submission that we need to try and get at, in one way or another, what their intentions were on purchase, not what their later intentions were. It's not been suggested there was any change in their intentions, which can sometimes happen. I haven't quite understood why what somebody says they intended is irrelevant when they say it later. If what you're trying to get at is what they did intend, why, if Lloyd had said in 1988, when we bought the farm, what I understood and intended was that we should each earn a third of it, so that I would have a third to leave in my will. If he'd said that, would that be inadmissible?
Yes, unless it was communicated to the other party.
Why? Why is
Because that's the Gissing and Gissing point. Your subjective intention may be completely different, it may be wrong. What you subjectively understand to be the position is irrelevant unless there is actually a communicated common intention, because then it becomes a matter of agreement. And then you can objectively determine what that agreement is.
even if all three
And
similar statements? If they all said, my understanding was we'd have a third each. You'd say that's
well, if
I can see it might not be conclusive, but you say it's inadmissible.
well, they may have gone to professionals and asked those professionals, told those professionals what they wanted, and asked them to put in place a transaction that achieved what they wanted. They might not understand at the time exactly how that worked, only what the result would be. They may the reason their subsequent statements are positively dangerous is they might change their minds. For instance, if they intend to give a farm to the son that's the farmer, and then for 2 years the other son comes back on the farm, they might think, well, we might want, even though we brought our son into partnership telling him he was going to inherit the farm, they might change their minds. If that son then disappears for another 20 years and becomes a very successful businessman, they might change their minds again. Or but their subjective understandings at later dates are and particularly dangerous in this case because the solicitor made an assumption. The solicitor that was advising them, I think, in relation, the judge, I think, placed particular reliance on a 2012 will, which is when Gavin.
I thought it was 1988.
No, sort of 1988. Well, I apologise. Yes, 1988 will. And that will was drawn by Sarah Llewellyn Jones. She admitted later in 2014 that she had mistakenly made assumptions about the ownership of the property. And one gets that from the, I won't tell your lordship because of the time, to the, perhaps briefly, supplemental bundle 181. I've said 181. That's just a document that shows that at the time Sarah Llewellyn Jones was acting for both Gerwin and Lloyd. She sends a fee note to them jointly. Page 182. This is a telephone attendance on Gerwin explaining that she discovered from the land registry that there was a joint tenancy and not a tenancy in common. And she then advised him that they needed to do a severance of the joint tenancy immediately, which for safety I get served on Dorian Williams. Now, in fact, no such notice of severance was drawn at the time, and was served at the time. And she then, I don't know why she's on the same attendance name, she's amended Lloyd Williams' will and dictated a letter of wishes. But then 183, she puts it in writing to Lloyd, and she refers to her discussions with your son, Gerwin, that is. I confirm the land registry document state there's a restriction in place on the title and she says, bottom of the second paragraph, that the restriction should therefore not have been entitled, and that has misled me for many years. And therefore, in order to regulise the position, I need to give notice immediately to sever the joint tenancy. So, she had made, her father had acted when at the time of the purchase of the farms, but he died in 1985. Father's file has been destroyed. There's no suggestion as to when it was destroyed. It appears to have been in existence in about 2010, possibly in 2017, but was destroyed before trial. And Sarah Llewellyn Jones' evidence was positively destroyed, not just lost. So Sarah Llewellyn Jones came to the matter post the transactions. She jumped to a conclusion from the title and advised her, she drew the wills in 1988, which was post her father's death. In any event, those wills are consistent with what Lloyd and Catherine would have been understood to be their ultimate intention, which is that Cefn Coed went to Dorian. Now if on the basis that it is tenancy in common, they have left the farm to Dorian. But that is equally explicable by their solicitor having made a mistake as to what the legal position was, and advised them that if they wanted to achieve what they wanted, which was the farm to go to Dorian, they needed to make a will to give it. And that's another reason why I say it's positively dangerous, because this is a statement we don't know the circumstances in which it was given. The person who drew the will was not called, so we couldn't cross-examine her as to what advice she gave at the time the will was drawn. We can draw inferences from what she later said. And in any event, Lloyd and Catherine may have misunderstood the position. And the principal question and the first question is as to the context of the transaction, because that is whether any sort of quotes presumption will arise. And the most important contextual document, or the only real most important contextual documents are, the most important contextual document is the mortgage, which is a joint document and says in terms, and was no doubt executed by the parties, they jointly are the beneficial owner of the property. On one view, that is a declaration of trust.
Well,
Yeah.
does it say that in
Does
text?
it say that?
I thought it
Say
said
that.
the borrower, as beneficial owner, hereby charges.
Yeah.
The borrower is the three of them. The three of them were the beneficial owners on anybody's view. Whether they were joint beneficial owners or beneficial owners in common makes no difference at all to the mortgage company. The reason the mortgage company wants them to charge as beneficial owner is to get the benefit of confidence for title, isn't it?
Okay, I perhaps overstated that. What the document does show is it's joint borrowing.
But it has to be joint borrowing because they're joint legal owners. And so joint legal owners, even if they are beneficially tenants in common, are bound to jointly charge the legal estate to a mortgagee. You can't do it any other way.
No, my lord, I was going to make a different point.
But you place emphasis, you say the most important contextual document is the mortgage. From my part, the mortgage does nothing more than you would expect in any case in which the legal title is held jointly, as it has to be, as you know, and the legal owners wish to acquire the property on mortgage. The mortgagee will insist that all three legal owners sign the document because that's the only way in which they get a legal charge. I don't see that it really takes much further than that.
Well, my lord, in my submission it does, because it engages the presumption in the first sentence in the Gary and Wade in 12022. This was joint borrowing, so if it is joint borrowing, there is a presumption of joint beneficial ownership.
Right.
And that actually reinforces the legal position.
What, if
Yeah.
anything, does the fact that it was said that the reason that your lay client was on the mortgage was because his parents were too old to get a mortgage play in the overall contextual background?
That's an explanation. And that is why the relevant context is that they put Dorian on the farm because he was the farmer. It was, this is a family enterprise. The last thing, Lloyd had been tenant farmer for donkey's years.
Understood that
I'd say.
now. I was simply asking
And
whether
he
or
was
not-
determined to buy this farm. He was not buying this farm as an investment. He was not buying it for his separate purpose. He was buying this farm because he wanted it to go to the next generation. The next generation were going to get the benefit of this farm. He was never going to see the mortgage paid off.
Was there evidence to that effect?
Yes.
So that was the evidence before the judge. That was the sole purpose of buying this was for inheritance purposes.
Well, that's what the judge made the finding that they told Dorian he would inherit.
No, that's a different point with respect.
Well, yes, there was. Well, Dorian's evidence.
Yeah, of course, I think everyone accepts that, and it was found by the judge, so we're all bound by it, that at one stage he did say to Dorian he would inherit. Absolutely. What I was asking was the significance, if any, of the fact that he was on, so far as the purchase of the farm was concerned, was there evidence that the only reason that Mr. and Mrs. Williams Senior bought the farm was so that it could be inherited?
There was evidence from Dorian.
That was your submission, and
There
I'm
was-
just wondering where the evidence for that
There was
is.
evidence from Dorian, and there was also, I think, possibly evidence from others that father said at the time, I will never see this paid for. It was a 40-year mortgage. He was 65 at the time. He'd have been 105 if the original mortgage.
So you're saying him having said, I'll never see this paid for, you should draw from that he bought it solely to pass it on to the next generation.
Yes.
But
And he told Dorian he would inherit the farm. That in my submission, that he tells Dorian he'd inherit the farm. He's at retirement age. Dorian is the farmer. Dorian becomes the principal farmer by about 1992, but that's irrelevant because we're talking about the back in the 1980s. We're talking about the date of purchase. He takes one son into partnership with him. He tells him he will inherit. That is only consistent with his intention for the farm to be retained in the family and to go to the next generation. Unless he was being dishonest, which is there's no suggestion.
no,
If it was
what the judge records, and this is paragraph 20 of the judgment, it is not in dispute that because of the ages of the parents, it would have been difficult for them to obtain a mortgage for themselves. Dorian was included because he was younger and thus acceptable to the lender. Now that looks to me like a finding that was undisputed and that is what happened.
that's an explanation as to why they brought Dorian into the business.
Yes, because when they bought Crythan, which was a year before, which they didn't need a mortgage for and paid for in cash, even though they did ask the children to contribute, and they did contribute, they took it in their own name. So that tends to suggest that the judge has correctly recorded something, that when it comes to Cefn Coed, where they don't have the cash and need to borrow, the reason that Dorian is put on the title deeds is because the mortgagee insisted on it.
Well,
And that
well,
if I may say so, makes perfect sense. I mean, it seems to me to be obvious.
well, my lord, there is a real difference between the two situations. Crythan was, as your lordship says, effectively bought for cash. Cefn Coed was bought with 100% mortgage. It was going to have to be paid for out of the business.
Yes.
And the only person who was going to run that business on the arrangements that were put in place when they were no longer able to was Dorian. He committed under the partnership deed to give his full time and effort to the business. He was the only person in the money that was going to pay this mortgage was actually going to be earned almost entirely by Dorian. There was evidence the father did a bit of potting, I think it was described as, went round picking some weeds. But in commercial terms, the only person who was going to earn the money to pay for this mortgage was Dorian.
I thought the judge found that father carried on working despite his age for quite a long time.
Yeah.
I may be wrong about that.
He did in that paragraph 54.
Well, I think
that,
there was evidence as to what that entailed. He had a very serious illness, I think, in
most people would
91.
regard working on a farm as being a bit more than doing a bit of weeding.
But he certainly, he was 65 at the time. For however long he was going to be able to carry on for, he wasn't going to be able to carry on for very long. And if it was going to take 40 years to pay off this mortgage, in reality, the vast majority of the work on the commercial arrangements, if one's looking at it from a commercial point of view, was going to be Dorian, because he was the one that committed himself to working in the partnership and farming the farm as a principal.
Now, where have we got to?
And the other documentary context are the partnership accounts, and I've mentioned the joint account. I'd say that is important because it shows, this goes to the point in Stack and Dowden, that it may be difficult in a domestic relationship, or it might have been Jones and Colonel. It's difficult in a domestic relationship to account to each other. You don't account to each other in a family relationship. People took cash out of the farm when they needed it. And it was all sorted out at the end of the year by the accountant who drew the accounts. There was a stated joint account This was a communal family enterprise, even if looking at it from a commercial point of view, because there was one single joint account stated. This is not a case where each party was looking to their separate interests and keeping tabs on what was earned at what stage.
The legal position is governed as to their interests in the business is governed by the Partnership Act and the Partnership Deed. And under the Partnership Deed, as I read it, if a partner dies, their interest accrues to the surviving partners, but they have to be paid the value of their share. So legally, they do have separate interests.
Well, my lord, that depends on what was agreed between them. And my lord, we're going into territory that I can't really argue, but the account on the face of the authorities, accounts are conclusive evidence of the arrangements between the parties. And there are cases that say that if partners agree that the property is going to be joint, then that displaces any presumption of co-ownership. But my lord, that is an appeal that I'm not allowed to.
I understand.
And in my submission, it was simplistic just to say this is a business relationship, therefore joint co-ownership. And in my submission, wrong even in a commercial relationship because of the bearing away presumption. My lord, that leaves, I think, probably severance. And there's, as I've already mentioned, there's one line unreasoned comment in paragraph 64 in the judgment. It's omitted, and your ladyship and my lord have already seen the instance in which it's admitted that a form of notice of severance was executed on the advice of Sarah Llewellyn-Jones, and we've just seen that correspondence. But a form of notice wasn't served until much later. If one takes the supplemental document and goes to page 378.
May I just point out that in paragraph 45, the judge found that the notice was served in March 2014.
So that was paragraph.
45.
Paragraph 45 of the judgment.
Thank you.
I've even marked it up.
Doesn't he say executed?
Served.
So,
Paragraph
45.
One has to read the judgment extremely carefully.
It says served.
No, what the paragraph says, and one has to read this judge's judgments really carefully. Mr. Williams served a notice dated 3rd of March. So the notice was dated 3rd of March. It was not served until some 2015. We know that from the documents.
Does it matter? Does it matter when it was served?
Yes, it does. Because of the intention of the intention must be at the time it is communicated.
Why? I mean, if you sign a document and put it in a drawer and serve it a year later, surely by serving it, you're saying, I now want to sever. I don't understand why the...
Well, if your intention when you serve it is to sever, yes.
But that is what you...
That
is what you do by serving a notice to sever. You sever. You say, I want to sever it.
Well,
and if you're going to say, despite the fact that he did actually serve it and that it said on its face, I want to sever it, he didn't really want to sever it, but you have to put forward some argument to that.
Well, I'm getting there, my lord. If your lordship will bear with me.
But to the judge, don't you? And as I understand, you never put an argument to a judge that although it was served, it didn't mean what it said.
Well, my lord, it wasn't strictly even in in dispute on the pleadings, and it wasn't something that was canvassed at trial. If the judge.
You say that. I've been reading these opening submissions, which I find quite revealing, because you identify as issue 7, a question, one of the issues for trial, in which you say, what was the effect, if any, of service of notice purporting to sever the joint tenancy? So you do raise it as an issue for trial. All you say about it when you come to it is because it was partnership property, any notice of severance was of no effect because it requires the consent of all three parties. But in Mr. Pierce Smith's opening submissions, he goes into the matter in rather greater detail, and he says at paragraph 70, having said notice of severance is of no effect because it was held as interests in common, if that's incorrect, it's admitted that the notice was effective. And he says Dorian does not challenge the legal effectiveness of a severance, but challenges Lloyd's entitlement to sever, either because it's partnership property or was unconscionable. So that was his understanding. If you were to say to the judge, no, he's misunderstood that, I have an argument that it wasn't effective anyway, surely you have to say so, don't you?
My lord, I did. We exchanged skeleton arguments, and in my skeleton argument, I said it was only a purported notice, and that was consistent with my pleading. And the burden is on the respondents to prove an effective notice at trial. They did not attempt to do so.
Well, you say you did.
My lord, can I just? I do need to take you
Yes.
through to some of the documents quickly because we're coming up to supplemental bundle. Sorry, application bundle 2, because these are documents my learned friend has put in for this hearing. Page 378. Now, this isn't actually service of the notice. This is the first thing that was attempted on 18th of December 2014. Sarah Llewellyn Jones wrote to Dorian Williams, LD Williams, saying, I'm now acting on behalf of your father in connection with the administration of the estate of your mother. She says, it is presumed in law that Cefn Coed, Eaglebush, Neath is held by your parents and yourselves as tenants in common and equal shares. Now that's inconsistent with the advice she'd received, and what she says was the advice she'd given in relation to joint tenancy. Therefore, on your mother's death, 1/3, 1/3, 1/3. In order to record the position, I attach a declaration to that effect. And I'd be grateful if you kindly sign it as indicated in the presence of an independent witness who should also sign and return to me. Now, Dorian did not sign that. One finds the form of declaration on that page at 380 and 381. So when he hadn't signed it, one goes on to page 389. One has a client telephone record of an attendance on Phil Wintle, whoever was employed to execute the service of the notice of severance, and the client name is Gerwin. There is nothing. Sorry, that may be the. I may have jumped on actually. Sorry, it was. So 10th of March, there were simply instructions to the to Mr. Wintle to serve the original notice of tenancy, the notice of severance that had been executed in March 2014. No further instructions appear from the file to have been taken before that notice was served. Then, 390, Mrs. Llewellyn-Jones, Miss Sarah Llewellyn-Jones writes to Susan Ham, saying, on reviewing the notice of severance of joint tenancy, I note that I inserted your brother's name as Dorian Lloyd Williams, whereas I now realise it should have been Lloyd Dorian Williams. In order that there is no uncertainty, Please could you ask your father to sign the enclosed notice and return it to me? No evidence is given as to in what circumstances, and there was an opportunity to do so because Susan Ham was called, the document you find at page 391 was executed. A severance takes place by the communication of the true intention of the maker of the statement to another party, and in those circumstances, a court will recognise the effect is to sever the joint tenancy. But if that notice is given in terms of extreme suspicion, and I could take your lordships and ladyships through the entirety of the documentation.
Extreme suspicion.
Well, my lady, can I just give, can I give you some page numbers just to work your way through?
Was this your case, that this was effectively a fraudulent notice?
No,
Obtained at a time when Mr. Williams Senior wasn't fit to sign.
My case is that it was the respondents to prove, in the face of our saying that Lloyd's capacity was in doubt, and pleading all the circumstances in which we alleged that Susan and Gerwin had clearly been given instructions on behalf of Lloyd, and procuring the execution of documents, including this document. The burden was on the respondents to prove the due execution, in other words, that it represented the true intention of Lloyd at the time it was served.
This court, have to consider that submission against the backdrop of paragraph 46, of the judgment, where it was put to the brother and sister in cross-examination that it was all done for their own interests. Each denied it, said they were acting on the instructions. This is the paragraph following the severance details. It's common ground that he was a strong-willed individual. This part of their evidence came across vivid and genuine, and I accept it. So he accepted the Gerwin and Susan's evidence that they were acting in relation to the severance on the instructions of their father. Now, how can we go behind that finding, which you're asking us to do?
Well, my lady, that is not, it is not enough just to see a witness in the box where there are doubts about capacity and simply to say, I believe them in the box that he had,
Why not? Why not? It's a finding of fact. That was a finding of fact he was entitled to make. Well, why are we not bound by that, as my lady said? I mean, you might have said that finding was a finding that he could not properly have made on the evidence, which I would have had grave scepticism about, but you've never said that, have you?
Well, my lord, this issue...
Now you're saying it now.
Well, my lord, I am saying it now, yeah. And my lord, in my submission, the only fair thing to do in this case, given the circumstances, and given the fact that this did not really feature at trial, would be to allow the appeal to find it is a joint tenancy and refer the question of whether or not it was severed back to a judge at first instance.
And that's on the basis that the finding that this judge made at paragraph 46 was something that was not open to him on the evidence.
Well, my lord, it didn't form part of his decision, and it is not therefore raised.
You say it didn't form, but it did. He decided. We saw this earlier in paragraph 84 that the notice of severance was effective to sever any joint tenancy that existed. And these paragraphs, 45 and 46, are the basis of that. He finds that the notice was served. He finds that it was served by Mr. Williams, and he finds in 46 that it wasn't a put-up job, but that he he actually was the one who gave instructions and wanted it done. Now those are collectively findings of fact on this issue.
Well, my lord, the best submission I think I can make is that, I'm conscious of the time, I'll make it very quickly,
No, that's fine. You've 4 minutes to make.
is that this does not form part of his decision which led to his order. Therefore, it is not res judicata between the parties. It is an alternative finding he made under the judgment. But so it is not, and it is an alternative finding that was made in circumstances where the point was not fully argued, wasn't even pleaded, and wasn't fully argued at first instance. And I do say that it is not enough in the face of the documents before the judge, which he didn't deal with at all. This was an unreasoned statement. And there is a huge history of documentation in this case.
So
And in those
so you
circumstances-
are saying he couldn't have reached that conclusion given the documentation?
Not without many, many more reasons and an analysis of what was happening at the time. And in 2015, not in 2014. And he hasn't seemed to even turned his mind to what was happening in 2015. And that was after you've seen the very confused statement that was drawn in October 2014, which appears to have been signed at or about the same time as the notice of severance, the second notice of severance, in the same pen, it looks like, without any amendments being made to that statement, even though it is obviously wrong on its face.
Thank you.
Unless I can make any further submissions.
Anything else? No, thank you very much indeed, Mr. Adams. Might I just say you've been extremely helpful. We've asked a large number of questions which have assisted us greatly in our understanding of your case and how you put it. So we're very grateful. Thank you. So 2 appeal, please.
Okay. Yes. I think I'd do this really. I'll certainly do that.
Yes.
Yeah.
Sure you'll be able to leave
I think we should be able
valuables
to
in here
do
because
this
it'll all be locked up, won't it?
Yeah.
Protected.
Yes.
Protected with the usher's life, I'm sure.
Yes, they should lock up over the lunch hour, so I might actually wear my coat. Sorry, did you say you're locking the room during the lunch hour? Fantastic. less things to carry. Right.
Thank you.
turn it off. It has finished but late.
No, I saw him finish. Definitely off, isn't it?
Yeah. Let me check the on the app.
Check on, yeah.
This is live, but there's no footage. It's not advancing.
That's a bit weird.
Try stopping it again just to make sure.